thank the organizers, in particular Nina Brion and Pia Tillmann. Also thanks to Heiko Hoffmann for guiding us through the discussion later on. I want to open the floor with a few brief remarks on the overall theme of copying, of quoting and citing, concepts and ethics of quotation. Myself, I'm a philosopher at the University of Münster. My research focus is in aesthetics and the ethics of copying. I've been working with a research group at the University of Bielefeld's Center for Interdisciplinary Research. We were quite lucky that Lionel Bentley and a couple of other copyright scholars contributed to this group, together with philosophers, social scientists, media scientists, and scholars from art history, music, and literature. We've learned a lot about copyright, what it's needed for, why it is the way it is today, and how it might perhaps be improved. And that's why I'm here today, because copyright law is essentially about the question who may use certain signs or images or musical material, and who may demand from others that they refrain from using certain signs or images or musical material unless they get a license. I want to start with some remarks on copying and citing, and then focus on controversies about secondary use of musical material and the Kraftwerk case. I know that probably most of you are here today because you're particularly interested in that latter topic. So quoting is a type of copying, and the ethics of quotation is an important part of the ethics of copying. You can quote me. Eberhard Ortland started with the claim that quoting is a type of copying. Of course, you don't need to quote me for that, since you already knew that. On the other hand, if I just copy my sentence stating that quoting is a type of copying and put inverted commas around them, I'm still not quoting that sentence, nor quoting myself, I'm just repeating myself. According to the Oxford English Dictionary, quotation is used primarily with regard to certain speech acts and the linguistic material used in speech acts. It is, I quote, a group of words taken from text or speech and repeated by someone other than the original author or speaker, unquote. There are two moves involved in quoting: taking something, picking up or borrowing some form of expression from someone else, and repeating it, saying a certain phrase again, writing the same words in a different context. The paradigmatic situation is that you have, on the one hand, an original author or speaker who said or wrote something, allegedly for the first time, and, on the other hand, a second person who has heard or read the first speaker's speech and now picks up a phrase or even a longer passage from that text and repeats this group of words, incorporates it in her own speech. Like what I have done right now with this dictionary definition, even though I do not consider it to be original in any sense. The miraculous thing is that the words that have been taken from the other's speech remain in some sense the same, while their meaning may change according to the context into which they have been adopted. This is really not special at all. Every child does it. We do it all the time. We could not get into the language that we call our native tongue, or our mother's tongue, as the Germans put it, without picking up words and phrases from others and imitating, repeating them. And this is true not only for our so-called natural language or our second languages, but at least to a certain degree, also for the languages of art, to quote the famous title by Nelson Goodman. In order To be able to make music and even to appreciate music, you have to be acquainted with the musical vocabulary and grammar, a shared social practice of musical forms that become remarkable and meaningful as they remind you of something you have heard or maybe even played before, or because they are different in a particular way different from what you have been used to know. Quoting, borrowing, sharing forms of expression, and even referring to forms of expression that you would not want to adopt as your own, quoting is always social interaction. It is not the only type of social interaction, but arguably the most important, and certainly the most common and most encompassing dimension of social interaction. And social interaction is full of conflicts, and conflicts need to be resolved, and that's why we need an ethics of quoting. We are inherently social animals and political animals, as Aristotle said, because we are mimetic animals. We share our common language or languages. We incessantly copy and imitate, emulate, quote, or mock each other. We become capable of expressing ourselves only by taking up and maybe transforming forms of expression that we have previously encountered in others. The Russian literary theorist and philosopher of language Mikhail Bakhtin notably put it this way: our speech, that is all our utterances, including our creative works, is filled with others' words, varying degrees of otherness or varying degrees of our ownness. These words of others carry with them their own expression, their own evaluative tone, which we assimilate, rework, re-accentuate. This is true, as Bakhtin claimed, not only for speech or language, but also for any kind of creative works. Therefore, it is common to use the word quotation not only for quoted words or sentences, but also for other forms of expression, for example, in music and the visual arts. Besides verbatim quotations, also, I quote again from the dictionary, a short musical passage or visual image taken from one piece of music or work of art and used in another can be a quotation. It's noteworthy that, according to this dictionary, only a short musical passage taken from one piece of music and used in another may count as quotation. It's not quite clear how long or short a musical quotation may be or ought to be. Anyway, there should be a boundary somewhere that distinguishes a quotation from a reproduction, from a performance, or a cover version of a piece of music, or of a substantial part, say, a particular movement of such a piece. The criteria may not be perfectly clear, and they may vary according to the length and character of the piece of music that adopts some short part of another piece, but there should be a boundary somewhere, and I think we have to discuss about that. Perhaps it's wrong, though, to assume that it must be a matter of quantity, of absolute or relative length. Other aspects might be relevant to distinguish a quotation from copies that should not count as quotations. For example, how does the adopting work relate to the work from which a sample was taken? We should be careful, however, not to draw the criteria for such a distinction in too narrow terms, because that might rule out types of quotation that are generally regarded as perfectly legitimate. There's no reason to assume, as the dictionary did, to assume that the relation of quoting should be restricted to works of art as the only kind of source from which something can be quoted in a piece of music or visual artwork. I accept that you would not want to call it a quotation if, for example, a composer uses transcriptions of typical patterns of birdsong as musical material. This may be an interesting case of the classical conception of art as imitation of nature, but most of us want to restrict the concept of quotation to quoting what other humans have said or done or made. So can you quote a bird? Still, there's so much more than merely works of art that can be quoted in art or music or in all other kinds of works. 100 years ago, Dada artists like Hannah Höch produced collages, quoting and arranging snippets of photographs and other images taken from various sources like the yellow press, political pamphlets, or technical drawings. Following pioneers of noise music like Luigi Russolo and inspired by radio and sonic film soundtracks, avant-garde composers like John Cage or Pierre Schaeffer in France, since the 1940s began to compose music with recordings of sounds and noises that were not reproductions of musical performances. After the Second World War, magnetic tape recording technology became increasingly available, and electronic studios allowed for remixing and blending sounds in ways previously unknown. As you all know very well, digital technologies made all this much easier, cheaper, and mobile and pervasive. That's where we are now. Likewise, found footage films can be made up of samples of other movies that were works of art in their own right, but they may also include footage that never was part of a previous work of art, but was taken, for example, from documentary footage, TV programs, or educational films, and increasingly also from private films or videos. Fashion notoriously quotes anything. It quotes works of art, and more typically, classical styles, but also corporate designs or brands by other companies or organizations. Contemporary car design often quotes classical models from the heritage of the same company or from other manufacturers. We are all very familiar with such quotation practices, and there are many more indeed. Why do we quote? We quote role models that we honor, with whom we identify, and with whom we want to be identified or affiliated. We quote authorities in order to remind ourselves and others of what we think is right. We quote authorities in order to borrow their authority. We hope to gain authority for certain claims we want to make. We quote others whom we want to criticize or hold accountable. Historical documents, but also photographic images and sound recordings, can be quoted as testimony, since they contain traces of past moments. There are many reasons why we may want to come back to particular moments later on, and it may be important to be able to refer to such traces. In the sciences and scholarly literature, we quote research results of others that we presume as valid in order to be able to base our own arguments on certain assumptions without having to prove everything we accept as right. We are bound to quote and cite our sources in academic writing in order to make it easier for our readers to trace these sources and to control both their reliability and what we have done with them. The obligation to quote exactly and to cite properly is also relevant under certain circumstances in journalism, politics, and diplomacy, in certain criminal proceedings or litigation, whenever it matters for some important question to establish precisely to whom a particular utterance or speech act can be attributed. Changing the wording of what, for example, a state representative said on a particular occasion and attributing to that representative something she didn't say at least not exactly in the way she is later quoted by some negligent journalist or political adversary, may under certain circumstances lead to a serious political crisis. Since ancient times, quotations from prestigious sources have been used as adornment of speech and were even required by classical rhetorics. Often we repeat or quote witty phrases, gestures, looks that impressed us or that we admire. We borrow their wit or splendor since we feel a need to display some ourselves and fear that we could not do better at the moment. In music and the arts, as well as in literature, there's a long tradition of starting with a model, a motive, an image, or a phrase taken from some source and somehow playing with it in variations, contrast, parody, pastiche, or satire. The obligations to quote exactly and to respect the identity of the source, as well as to give credit and cite properly, that are widely accepted in certain use contexts, are paradigmatic for the ethics of quotation. Everybody knows this, and most of us accept it most of the time and act accordingly. Failure to quote adequately or to cite properly can get us into trouble in certain contexts. Attributing some allegedly scandalous utterance to a person who never said such a thing can be a joke, but it may seriously harm the reputation of that person, and that could be a tort or a felony. And simply taking someone's work to fill a gap in one's own speech or literary, artistic, or scientific work without giving due credit may amount to plagiarism. This is what apparently was at stake in a prominent case that has been litigated in Germany for almost 2 decades now without conclusion so far. It's been up for trial at the European Court of Justice in July. We are going to hear more about that from Lionel Bentley in a minute. The case was and is about a sample taken from the percussion piece Metall auf Metall, Metal on Metal, from Kraftwerk's iconic 1977 album Trans-Europa Express, and used in Sabrina Setlur's song Nur mir, Only Mine, a top 10 hit in Germany in 1997, produced by Moses Pelham. The case was widely reported, at least in German newspapers. We want to take a closer look now at both pieces in order to make up our minds if the use of the sample might count as quotation. Pelham is deeply influenced by hip-hop music. Nur mir contains samples from various sources. The database at Who Sampled has identified 4 different sources, but I'm quite sure that there might be actually more. Maybe some of you can point out some further samples. The sample at the center of the Kraftwerk litigation is really short. A rhythmic sound fragment of 2 seconds, something like a tick-tick, tick-tick-tack. It was not regarded sufficiently original to vindicate a musical copyright claim in the first place, which is the reason why Kraftwerk resorted to their ancillary copyright in the sound recording. In German, it's Leistungsschutzrecht des Tonträgerherstellers. It's not easy to tell which moment exactly from the rather subtle and on the surface pretty monotonous Kraftwerk piece was actually the source of the sample that was used and transformed by Pelham. Apparently, digital pattern recognition software has established that it must have been one particular moment in the 37th and 38th seconds. Most listeners won't be able to identify it precisely without painstaking comparisons. Anyway, the Kraftwerk sound is recognizably present, in particular in the opening sections of the Setlur song, and it accompanies the song throughout, although it's not discernible in every moment. One can argue that Pelham has built his piece on this beat. The sample has been slightly modified and looped and is reiterated throughout the entire piece. On the other hand, there are also other rhythms, funky beats, guitar riffs, and most notably the rapping and singing by Sabrina Setlur, which dominate the oral impression. But the Kraftwerk beat serves as the song's rhythmic backbone, and the Kraftwerk sound contributes decisively to the cool industrial atmosphere against which the female self-assertion of Sabrina Setlur's voice bursts out. I suggest that we start listening to the beginning of the Setlur song until the refrain comes up. Then listen to the first minute of the Kraftwerk piece, and then return to the latter part of the Setlur song to hear how the beat made up from the Kraftwerk sample is still there, but under several layers of other musical material. Also, a second rhythm track that dominates already from the around the 20th second, as you will hear. Let's begin with Nur mir. Oh, sorry. Just a moment. Ich muss mal eben aus dem Programm herausgehen. Und hier das iTunes anschalten. Okay, that was the beginning of Nur mir. Here's Metall auf Metall from the beginning. Okay, did you notice the sample? It's in the, as I said, in the 37th, 38th second, and I just try to get this opened with this link because there I can see the second better, but no. Ja, und dann klickt es aber gleich weiter. No. Oh yes, okay, here we are. Wie komme ich jetzt wieder raus? Okay, sorry. Okay, this short beat, tick, 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 tack, was looped to produce the continuous synthetic beat that, sorry. So this is the graphic representation of the sample, and it was copied and copied and copied to give the rhythmic baseline for Pelham's piece. Now I jump into the latter part of the piece. Oh, come on.
Bis zu 40% auf gesunde Lebensmittel bei All You Need Fresh. Einfach gesünder leben.
Dann gehen wir hier rein, ja. Und dann haben wir es hier. So it turns into a guitar piece. And this is how it ends. Okay, what do you think? Should Pelham have the right to do with this Kraftwerk sample what he has done and why? Because it was de minimis, negligible, or because it was a quotation and he should have the right to quote the other piece and to do with the quotation what he does, not only just to refer to it, but also to build with it and make something new with it. That's the discussion I think we are going to have today. Thank you.
Good afternoon. I also would like to thank Heiko, Lyra and Pia for hosting me at this very interesting conference, event, etc. It's been fantastic. I particularly enjoyed last night, but I've enjoyed all the talks as well, so thank you. What I'm about to say derives from a much longer piece, and I ought to attribute my co-author, Tania Evans, professor at King's College London, who I'm co-writing this with, and it's a piece generally on the quotation right in law. And what you're going to get from me is builds on, differs slightly from the sorts of things that Eberhard has been saying, but is founded in questions of interpretation of legal texts that might apply to the Nuremberg decision. So let me start with the relevant legal texts. So the starting point is Article 5, Paragraph 3 of the Information Society Directive. This is an EU directive, so an EU harmonized law that limits what member states can do in relation to copyright. And it requires member states to recognize certain particular rights for the authors of musical works and also for the producers of phonograms, And those rights are identified in Articles 2 and 3 of the directive. And Article 2 is the right to reproduce the work in whole or in part, directly or indirectly. And that right is given in relation to musical works and in relation to sound recordings. And we had some discussion yesterday. Martin Kretschmer, in his very interesting presentation, talked about how that notion of copying, a very broad notion that covered uses in whole or in part, had emerged, and how that diverged from the 18th and early 19th century notions of printing and reprinting works. Article 3 of the directive confers on these same characters, authors of musical works, inter alia, and producers of phonograms, the right to communicate the work to the public or make it available. So under European law, all member states have to give these reproduction and communication rights to authors and producers of phonograms. Now, Article 5, paragraph 3, then contains a whole list of derogations or exceptions to those rights that are permissible for member states to have. And Article 5.3d says that member states may provide for exceptions or limitations in relation to quotations for purposes such as criticism or review, provided that they relate to a work or other subject matter, such as a phonogram, which has already been lawfully made available to the public. Unless this turns out to be impossible, unless this turns out to be impossible, the source, including the author's name, is indicated, so there must be attribution. The work must have been made available to the public. And then there are two key substantive requirements: that the use is in accordance with fair practice, and is the extent of the use is that required by the specific purpose. So you have a capacity for member states to have exceptions that allow quotations for purposes such as criticism or review, as long as they meet these four criteria. The work or phonogram has been made available, there's attribution, the use is in accordance with fair practice, and it's to the extent required by the specific purpose. Now, what I want to suggest, first of all, is that although this provision says may, member states may provide for exceptions, so it seems to confer a freedom on member states, then in fact there's an obligation on member states to permit quotations. So the first move I'm going to make, in a sort of parody of philosophers who say you can't make an ought from an is I'm going to try and make a must from a may. So let me do this by using a standard legal technique, which is to say, how are we going to interpret this provision? Are there other provisions that can help our understanding of it? And there is indeed another provision in an international convention called the Berne Convention. And the Berne Convention applies to 176 nations around the world, and is the international convention that says what rights those states must recognize for authors, and also says some things about limitations on those rights. And Article 10 of the Berne Convention is a remarkable provision because it requires countries to provide a quotation exception. So Article 10.1 says, it shall be permissible to make quotations from a work which has already been lawfully made available to the public, provided that their making is compatible with fair use and their extent does not exceed that justified by the purpose. Article 10.3 then conditions, which I haven't put on the slide, then conditions this on the attribution of the authorship. So you find within this provision, Article 10 of the Berne Convention, the four qualifications of the freedom to provide the quotation right that you saw in European law: that the work must have been available, that there must be attribution, that the use must be in accordance with fair practice and must be to the extent required for the specific purpose. But unlike the European provision, it's couched not as a permission to member states, it's couched as an obligation. And because of this, because European law is nested within international law, all member states of the European are parties to the Berne Convention, it would be the case that the Court of Justice of the European Union would interpret Article 5.3d in the light of those international obligations. So my first move then is to make a must from the may, and I do that in that way. Now I'm going to go on and talk a little bit more about Article 10.1, because Article 10.1, it seems to me, does something very dramatic and something that's not really been appreciated until recently. Properly understood, I say that Article 10.1 of the Berne Convention in fact requires parties to the Berne Convention to provide for something that is equivalent to fair use in the United States. So that properly understood, we have a globally applicable convention to 176 countries that mandates fair use. Article 10.1 is, in my view, global mandatory fair use. So, how do I get here? Well, the first point, first key step, is that the quotation that has to be exempt from the copyright owner's rights under Article 10 is not limited by purpose. Okay, so it includes artistic and expressive purposes. Now contrast the Information Society Directive that talks about quotations for purposes such as criticism or review. Some people would read that as saying the only quotations that fall within the exception are those for criticism or review or things like criticism or review. Now look at Article 10. It shall be permissible to make quotations, full stop. No mention of purposes. It shall be permissible to make quotations. The law could not be more clear in the Berne Convention. So my first move is to say the quotations that must be made by member states to Articles 2 and 3 of the directive are quotations irrespective of the purpose of the quotation. Now, if you think that's a bit ambitious, if you actually go back and look at the texts leading to the Berne Convention Article 10, so these were conferences held at an international level in the 1960s, you will find that the suggestion was raised on a number of occasions to limit the quotation right by purpose. And that suggestion was rejected on a number of occasions, confirming our view, the obvious view, that the literal reading is there is an obligation to permit quotation, whatever the purpose of the quotation. Okay. So that's the first key step. Now then I have two further steps in this argument. The first is that the Berne Convention covers a broad array of cultural fields. And therefore, the concept of quotation that it obliges member states to introduce, that concept of quotation must be one that is applicable to all cultural fields. In particular, it should not be understood as one that is equated with a print or text-based notion of quotation. Secondly, what I want to try and show is that if we look at examples, a bit like the way Eberhard did just a moment ago, we can see when we look broadly across the cultural sphere that the notion of quotation is very broad and very different from that text-based quotation. So that it ends up, in fact, merely as saying that uses, Article 10 ends up merely as saying that uses that are in accordance with fair practice and proportionate and attributed in relation to works that are made available must be permitted by members of the Berne Union. So this is what a text-based view of quotation might look like. If we think about the paradigm, and I think Eberhard alluded to this, of a quotation in an academic book or article, we would have a reproduction of a short passage taken from a much longer text, where the passage is presented as unaltered, or where there's alterations, there are dots, or little square brackets to indicate, and where the passage is presented as distinct, usually set in another text, the quoting text, which is usually longer, and which deploys the quoted text in its own argument, whether to support use the quote to support the argument, or whether the text contradicts the quote. And that would be a classic print or text-based conception. And what I'm arguing is that, in fact, Article 10 can't have that in mind. And it can't have that in mind because the Berne Convention is a convention that applies to musical works, artistic works, dramatic works, and film works. And that print-based conception would make no sense in those other cultural environments. So then when we move to those other cultural environments, the question is, what does quotation mean? And I just am going to give one example, which is art usage. And I want to give an example that may well be very familiar to you, and to ask the question, how do art historians think of this particular use? Do they think of it as quotation or not? And if they think of it as quotation, then what does that imply for the legal meaning of quotation? And the example is Manet's Le Déjeuner sur l'herbe. Very, very famous picture. You will all be familiar with it. It's kind of regarded as a central moment in the development of modernism in painting. It is involves rather beautiful and amazing application of paint. At the same time, it is an extremely odd and confronting image of two Parisian men, one bearded, having a picnic with a naked woman, as you do in the suburbs of Paris, while in the background there is a woman who's cleaning her feet. And she's sort of in the background, but maybe she's half in the foreground as well. She sort of occupies a very strange position. So this very famous picture from 1862 is well known as being based on, indirectly on a Raphael drawing via an engraving by Raimondi. And at the top left of your screen, you can see the whole of the Raimondi engraving of the Raphael drawing. And in the bottom right, you can see an excerpt taken from the bottom right of the Raimondi engraving. And if you look at that and then compare it with the Manet picture, you can see immediately the various aspects of the disposition of the characters have been derived clearly from the Raimondi engraving. Of course, the three characters are no longer water gods and river nymph. They're Parisians and a naked woman. They are Parisian men and a naked woman. Their attitudes are slightly different, etc., and obviously their meaning has been changed. So the question I want to ask is this the sort of thing that an art historian would call a quotation? And the answer is, if you go to the art history books, yes. So I looked at the commentaries on Le Déjeuner, and Michael Fried, one of the leading commentators, says Le Déjeuner is perhaps the most notorious instance of quotation from the old masters in Manet's oeuvre. Fried explains that three foregrounded figures in Manet's painting are a direct quotation from Raimondi's engraving. But he's not alone, so I have two other sources, Beatrice Farwell and Carol Armstrong, each of which also talk about this in terms of quotation. Beatrice Farwell asks, why did Manet need Raphael? And explains that in using Raphael, he was invoking an ideal, referencing the past, etc. It is this and not weakness of imagination that lay behind Manet's quotations of the old masters. And in fact, Manet is very well known as having participated in these kind of practices in relation to a large number of old masters, Titian, Watteau, Velázquez, and so forth. So what do we get from that? A cultural rather than a textual conception of quotation is not limited by these characteristics of a short excerpt taken from a longer piece, presented as distinct and used in direct commentary or explication. Rather, the notion of quotation as used in art, and I think in culture more generally, includes imitations and transformations as well as replication. No requirement of distinctness, that's just incorporated within Manet's work, and need not have any explicit kind of commentary on the work. So then the question arises, well, is that true of sampling? And yes, commentators on sampling have equally described sampling in terms of quotation, and I have some examples there on the slides. Mark Katz talking about sampling as performative quotation, and Kevin Home-Hudson as timbral quotation. People like to try and create subcategories of quotation, but there is, I think, quite broad use within the sphere of the term quotation. Now, I'm going to just conclude there. I was going to add in a little more complexity. I think there's probably enough complexity already here for most of you on a Sunday afternoon. But the conclusion would be that the reuse of musical sound will always be a form of quotation. And whether there is infringement depends just on these other requirements, whether the use is in accordance with fair practice, whether it's proportionate to the purpose of the user, and whether there's attribution. And with that, I will leave you for questions.
Okay, good afternoon. Good afternoon. Good afternoon. Okay, there we go. I want to make sure you're still with me. I thank my colleagues who went before me. I'm Tania Evans. I'm a professor of law at the University of New Hampshire School of Law, which is formerly known as the Franklin Pierce Law Center. And I am the chair of intellectual property and technology online programs. I write, speak, and teach about the intersections of copyright and technology. And I fell down the blockchain rabbit hole about 18 months ago and haven't survived yet. So I'm spending quite a bit of time talking about the intellectual property issues in or implicated by blockchain and distributed ledger technology. And so some of my marks will gravitate toward a connection between what my predecessors have said and also what technological tools might be used to further protect the rights of artists and innovators in the musical space. So I will pick up where my colleagues left off with the role of cumulative creation in music. One of the first legal or law review papers I wrote was titled Sampling, Looping, Mashing, Oh My, how copyright implicates certain protections for copyright artists. And that includes more than just music, but we'll spend our time and attention focused on music in particular. There's also a lot going on in various countries, what I describe as a seismic shift in the law, or perhaps a pendulum swing back to refocusing on the rights of creators and also of consumers who in this day and age actually don't just consume passively, but also seek to innovate. So I talk about them as being second generation creators or those who are borrowing or using quotation in various literary and creative mediums in order to create something new. That's the innovation, that's the forward progress that from a United States perspective is hardwired into our Constitution, which builds upon the Statute of Anne, which came from England. And finally, I will leave off with the role of technology in further protecting artists' rights. So in terms of cumulative creation in the US, there is much overlap and similarity because the United States is a member of the Berne Convention as well, and so we're held to certain standards, the 176 nations that was mentioned by Lionel. Originally conceived, however, it actually didn't apply to music. There were later iterations of the Copyright Act that began in the United States in 1909. By 1831, lyrics, so musical compositions, were protected. That protection was extended in 1790 version of the Act, and it wasn't until 1971 that sound recordings became protected. And so that's always interesting. There's a long history of protecting musical compositions, which is a separate copyright from the sound recordings on a master recording, for example. And it is interesting what's happening now. Just on October 11th, so this month, just a few weeks ago, or a couple of weeks ago, the President signed into law the Music Modernization Act. It was a major overhaul. It's the first major overhaul of the United States copyright in 20 years since the Sonny Bono Copyright Term Extension Act in 1998. Evidently, I don't know how it was done, but all of the stakeholders in the music industry came together to lobby Congress to enact certain protections, and I'll talk more about that as we move forward. Copyright exists automatically, so from the moment it's fixed and capable of being copied, is in some what we call tangible medium of expression, then that is when copyright subsists. There are certain protections and reasons for registration that we won't go into, but it's important to note as a signator to the Berne Convention that these rights exist automatically, which is the blessing and the curse in some respects when you have second-generation creators who are trying to make sense of what is protected and what is left available and enough for the rest. When we talk about the rights, sometimes we brush past them, but it's the right to copy and to adapt, to distribute, to publicly perform if it's capable of being publicly performed or publicly displayed. And therefore, sampling and looping and mashing all trigger copyright inquiries. That's not the end of the inquiry because of what was described earlier as fair practice, or in US parlance, fair use, and also de minimis use, that technically even if something is protected, that we still want to leave enough space for what the law calls a trifle of loss, not even worth the effort of fighting about. Perhaps after 10 years in the case that was mentioned earlier, they finally came to that conclusion after wasting a good bit of time fleshing out the issues. And from that, it's important to talk about what happens when the law is either uncertain or where you have parties that don't have the deep pockets necessary to protect their interests. So I feel that the space for fair use and de minimis use has been shrunken down exponentially, not because the rights don't exist, but because people don't have the deep pockets to fight out in an open court. Because even if you're sued or even if you sue someone, if you have to go to court, in some sense you've already lost, particularly if you are an independent artist. I spent most of my time in some of the law review articles talking more broadly about music, but looking in particular at hip-hop law, hip-hop music, and more than music, the culture. And it's interesting what was said earlier, because we have this idea of borrowing or quotation, again, not just from a literary text, but in all areas of creativity subject to copyright. When I think about hip-hop music and the fact that DJing is really the backbone of hip-hop, and also understanding the origins and the role that citation, quotation, homage plays in the hip-hop music area. So started in the Boogie Down Bronx, that's how you have to say it, which is in New York City in the early 70s. And it was quite by accident when DJ Kool Herc was DJing a party and isolated a heavy percussive beat to a recognizable R&B tune, and then he rapped over it simultaneously. And that was really the birth of hip hop. And it was taking a little bit of this and a little bit of that, those things that already existed, and creating something new and innovative, something we would call transformative. That would be the subject of a fair use or fair practice. It grew on from there, continuing to borrow from classic R&B hits at the time. It grew much more exponentially after that. and that music would be in the background. That also ushered in the idea of cutting and scratching, using two tables, a microphone, and a fader going back and forth to bring up and push back music. And that was an integral part of that type of music. Going beyond there, there was also, at the same time, these technological advancements. So moving from physically manipulating vinyl to doing so digitally, and be able to adjust music, to speed it up, to slow it down, to compress it, to take those oral fragments and to create music. So the stock in trade was actually the beat and the music. They were used as tools of creativity. That was, to quote Lionel a bit earlier, not weakness of imagination, but the height of imagination, of taking what already exists and making something new. So when I talk, Public Enemy is a classic example. So their greatest record of all time from PE or Public Enemy was It Takes a Nation to Hold Us Back. And that involves hundreds, literally, of oral fragments. I call it a musical collage. It would be cost prohibitive to create this at this time because of the licensing culture that would require an artist, if they were going to take one, let alone 300, to have to pay for them. But Public Enemy distinguished itself early as this sampling as art trailblazer. And many artists started to copy that as well. Their legendary status was the very reason that they were creating these musical collages. At the same time, not only the industry, but certainly the law was taking a keen interest in a negative way in the music and making it, nobody cared when it was in, a small basement in the Bronx, but they cared very much when hip hop became a global phenomenon that pressed the issue from a rights perspective when all of a sudden there was a mass infringement race to sue as many people as possible and to secure. And so artists were clearly negatively impacted from a sound recording perspective because samples are direct copies of a sound recording protected by copyright. And those infringement claims really broke the back of the industry and hip hop music. And that also brought forth this idea of the negotiated licensing, where people are just not going to take any chances. They're going to err on the side of caution, figure out how much it's going to cost, and pay. Maybe they'll take one sample and loop it, as was talked about earlier, and not risk being sued. There's an interesting case in the United States known as Bridgeport v. Dimension Films. A lot of people talk about the blurred lines case, but that's really a plagiarism case. It's not a direct sampling. And so you have to go to the Bridgeport case to really see how a US court might approach it. I will say, and so long story short about Bridgeport is the court held that there was no de minimis use and any amount of a sample would be per se infringement. Now you can look through the entire act and there are a lot of words, but those words aren't actually included. And so many other circuits disagree, and Nimmer on Copyright, the leading treatise author, also disagrees. But that is still the law in the Sixth Circuit, and it lends itself to something that's quite curious about whether or not there is any space for fair use, for de minimis use. And from the perspective of the United States law, this balance when the copyright monopoly was created, that it would be for limited times, but ultimately would be returned to the public domain because it's this rich idea of creativity and innovation that spurs the development of society. So it's as if the law says, we'll let you borrow it for a while, but we're going to need it back. And by we mean the citizens, because this is ultimately important from the richness of history and creativity. So how is this evolving today? I mentioned this idea of the music, or the act, the Music Modernization Act that was signed into law on October 11th. It combines three separate bills that are very important, and actually it's quite, again, interesting that the entire industry came together and supported the enactment of this act. The first title creates a new licensing collective. So there would no longer be this division of performing rights organizations collecting on behalf of their members and then giving them pennies on the dollar. Now you have one licensing collective. You have a new mechanical license that's been created, and a new fee dispute resolution system specifically for digital music. The Classics Act focused on and created what had never been in existence before, but a pre-1972 protection of sound recordings. So you might remember earlier I mentioned that 1971 going forward, sound recordings were protected, but those before that time were not. And so the Congress has created a protection for some of the old hits. They're giving them quite a window. So you'll see that it says, the right that didn't exist before this passed will now protect sound recordings that weren't protected until 2067. That's a few years. I'm not quite sure what limited times means anymore, but it's quite extraordinary to retroactively create rights in that way. And I'm agnostic about it, but it is really breathtaking to see what has been created. The final one focuses on producers of music. So oftentimes producers are including some type of creative element, but often don't get compensation, and so it compensates artists in that way. And so when I think about the future of digital music rights, and I also think of some ethical issues that come up here as well, I think of the ethical challenges when we think of all of the intermediaries in music that come between the artist and the user or the consumer. All the stops along the way, and from an ethics perspective, whether or not that is fair to the creator to get so little of the economic benefit of their creativity. So what are the current methods of distribution? And I'm speaking specifically about digital music, and the MMA focuses specifically on digital music. So there are actually over 30 different digital, has to be more than that at this point, but at least 30 different. I took a look at CD Baby before coming here about all of the different methods of digital distribution and how little, if any, of that remuneration makes its way to the artist. In my not-so-spare time, many years ago, performance poet, have a CD, and then sometimes I go in for S's and giggles just to see how little money I've made in a quarter, and it's quite insubstantial, but I do get pennies every now and then for people who are playing my music, and it'll be interesting to see what changes once you have some dedicated repository and distribution point. I put this up super small, so sue me, but it shows you all of the different intermediaries, again, between the artist creating music and then the consumer. It's a hodgepodge of intermediaries for composers, for sound recordings and public performances and all the licensing and distribution deals that an artist has to make. And so perhaps there's this better way, and maybe through technology, we might be able to remedy some of the legal challenges and some of the ethical issues that arise in creativity and distribution of those creations. At a very high level, just for a few minutes, for those who are not familiar with blockchain and its role at all in music, I just wanted to set that up. We talk about blockchain technology as the advent of Web 3.0, that it's called the Internet of Value. We've created a lot of value in Web 2.0. We talk all the time about data privacy, data breaches, and we sign up for a lot of free things not knowing that no app is truly free. And if they're giving it away, they're probably taking everything but your firstborn child. So how does that change in the next wave of technology? This is what computer network evolution looks like. First, centralized and static. You go to a website, you read it. You might go to a chat room, but there's no engagement. You move from there to something that's decentralized, where you have a few huge intermediaries, Facebook, Google, eBay, Yahoo, and they control the lion's share of the information that's disseminated. And in the Web 3.0 world, it's fully distributed. And that can be very powerful for creators in this day and age if they properly leverage that. And we'll talk about why. Blockchain is basically a distributed database. If you think about your text messages when you're group texting, everybody sees it, everybody has a copy of it. Just because you delete it on your phone doesn't mean that it's deleted everywhere else, right? It's this a novel way of arranging information that's replicated and shared and synchronized with a group of other computers. Generally speaking, it's permissionless. Generally speaking, it's public. It's transnational, so it removes borders, and it also removes the clogging point of intermediaries. And as we saw from the previous slide, there are many intermediaries in music. What would music data unchained look like? So certain metadata is involved. Who's the artist? What's the name of the album? The title track? The genre? There are bits of information that are very difficult to get, even if you're the artist. And that's an ethical problem as well, because the large intermediaries are the ones in control of the data that is generated by their artists. So, and it can often be incomplete, out of date, erroneous. There's a lack of transparency, and there's certainly a lack of trust. And those are all things, when you have the absence of trust in business, cause all sorts of ethical concerns. And so there are a couple of projects I wanted to let you know about. There's a longer list at the end of this slide presentation. I'm happy to share it with you. We can chat afterwards. But Blockchain Media is one of the really exciting projects that is actually working with those various intermediaries to empower authors by creating a certain, what they call minimal viable data, so that there's not one siloed intermediary that controls everything, but it's actually shared to further empower artists and users to find basic information. And finally, there's this group called Ujo Music, ujomusic.com. You might know Imogen Heap. She's a fantastic artist that decided to only release her music through Ujo Music. It's built and recorded on a blockchain, every transaction. She's able to allow people to buy instantaneously from her and receive money in crypto. She could code her smart contract so that she could be paid every time it was transferred, or have nothing. She can control her rights and permissions directly from the technology. So perhaps technology will alleviate some of the things that are greatest concern in the music industry from the artist's perspective, and quite frankly, also from the user's perspective. You're not going to be able to read all these necessarily, but I wanted to give you an idea of all of the projects being developed right now. Most of them are in beta and just shy of a white paper, so we're kind of years away from most of them being successful, but it will be really fascinating to see in the years ahead about how technology might be used. I think of the internet peer-to-peer technology as being, and digital technology as being the bane of the existence of artists, where people can make perfect digital copies and share without exhausting. And blockchain changes that. So the same technology that was used to disempower artists in Web 2.0 might be used to empower them in Web 3.0. And I look forward to your conversation and your questions.
Hello, my name is Heiko Hoffmann, and we wanted to follow these presentations with a discussion, but unfortunately we don't have much time left for discussion. So what's important for me is maybe also to give you the opportunity to ask a question, but I would like to ask with a question myself, and this is coming back to your initial, or how you ended your presentation, Eberhard. The question concerning the Kraftwerk versus Moses Pelham case, and you were asking everyone's opinion. Should Moses Pelham have the right to sample this piece of metal or not? So I would like to ask you, the audience, maybe you can think about your opinion for a second, and I'll ask you if you think he should have the right or not, and please raise your hand what you think. So the question is, do you think that in this case Moses Pelham should have had the right to sample the metal piece without asking? Please raise your hand if you do think so. Okay, thank you. I think I counted 13 hands. And who thinks he should not have the right to sample that piece of music without asking for permission? Yes, please, a little bit higher. 1, 2, 3, 4, 5, 6, 7. Okay, I think I counted 7 or 8 hands, so that's about half of it. So that round goes to Moses Pelham. Do you have an opinion yourself, Eberhard?
Well, yes, I did raise my hand, and I strongly support the claim that he should have the right to do with the sample what he has done, although I'm not too enthusiastic about the result that he has achieved. But still, he should have the right to do the best that he can do. And any other artist should have the right too. And now the question, why should he have the right? And that's, I think, the point we're going to discuss. I think there are basically two arguments that are possible. One is the suggestion introduced by Lionel. Lionel says, because we have already right to quote, and it's written down in the Berne Convention, and state law is required to make sure that every citizen and every musician and creator can claim their right to quote and to do with the quotes whatever the practice of quoting includes, and this clearly includes the kind of behavior that we've seen in Parliament and in hip-hop too. So that would be the rights-based approach. And the other approach, and is more conventional, I think, would be, well, actually, the snippet is so short, it should be regarded as de minimis, not only in musical copyright, as it was regarded as de minimis, and not sufficient to base a musical copyright claim in it, but also regarding the ancillary copyright, the Leistungsschutzrecht. It should not be possible to enforce such an ancillary copyright for such a short and insignificant snippet.
Mm-hmm. Thank you. And Lionel, what is your opinion?
Is this working?
It is?
Yeah, my opinion is... Okay. Yeah, my opinion is that this should be permissible. I could address the de minimis point that the directive only requires control of reproductions of parts, and there's a question then about whether this would constitute a part of a sound recording. And again, if you look at the international history, you can see there's an international convention known as the Geneva Phonograms Convention, where the notion of part is recognized, and it means, in that context, a substantial part. And when the Geneva Phonograms Convention was agreed, the sorts of things that a part was intended to prevent was somebody reproducing a whole track. Okay? Nobody conceived that we might be talking about taking 1 or 2 seconds. So on that level, I think that this is not even something that would be recognizably a part or meaningfully, legally a part of the work. But then it falls, to my mind, within the right of quotation. And the question then is whether it's in accordance with fair practice. And it seems to me that it self-evidently is in accordance with fair practice, partly because there's a very substantial creative, maybe not to all our tastes, contribution from the producer of Numer. And there's no economic damage produced by using this sample to the interests of Kraftwerk or the owners of the copyright in the sound recording.
Tonya?
The only quick thing I would add, because I agree in concept in the basic notion that fair use, fair practice would kick in. The only hesitation I have is when I think of one of the 4 factors which deals with the amount and substantiality, that there could be an example of using an entire work and having it still be fair use. Or the corollary to that is that you could take a very small part, but it might be the heart. And so even if you've only taken what would otherwise be considered quite small, if it's the one piece that is so integral and important, that might, now it's just one of the factors, right? Because you still have to go back to the economic consequence, the reason or the character and purpose of use, the nature of the copyrighted work. Some things receive a greater degree of protection. But that's the difficulty of even the discussion, that you don't know until you know, that there's this ex ante determination that we would love to have, that we don't. We have to wait, right, until we are in court to try and parse it out. And that makes it really difficult for artists to figure out where they fit in.
And maybe the question is not only to ask if Moses Pelham in this case should have had the right to do this without asking, but then also if you think he should have, should he also be obliged to give credit, and should he share some of the profits? And if so, what percentage should that be?
Well, man, that's a lot. That's what people pay $300 an hour to figure out. And if you're struggling with it, you talk to me afterwards. I'm happy to talk with you about it. Yes, that indeed is the question. So, I mean, the short answer would be to the extent that well, from a moral rights perspective, because we don't honor moral rights except in very limited instances in the United States, from my perspective, it would be a short no. Now, when you talk about the reasons that people quote, and you want to pay homage, and you want to stay in with the culture and the community, I think you give a nod as a matter of ethics. So we go back to the may, the must, the should. So normatively, if you want to be an active participant in the hip-hop culture or whatever your genre is, then you don't want to be an outcast by lifting something and not attributing, even if you're not required by law to do so.
I had two further thoughts about this subject, and it doesn't have so much to do with the court decision, but just two observations. Is that a couple of months ago, I was having a conversation, not on this stage, but in a room further there, with Karl Bartos from Kraftwerk. And what was interesting is that this case is called Kraftwerk versus Moses Pelham, but what it actually is, it's not Kraftwerk, it's Ralf Hütter versus Moses Pelham, who is the sole remaining member of Kraftwerk and the owner of that sound recording. And Karl Bartos was actually the drummer of and partly songwriter for Kraftwerk, and he is the one who not only came up with the pattern but also played that very pattern that we hear on that song. But he doesn't own any of the rights to it. So I asked him what his perception was, and he was interested in the court case, although he's not a participant in it. But because he's coming from a more classical music background, he was a classical drummer before, he said that he should not have the right to do this. He should just, if he likes the pattern so much, he should just replay it. But that also brings to mind the very, maybe that the whole idea of copyright is a very Western notion of what is there to be copyrighted, and what it is usually a melody and the harmony, but not so much individual sounds or rhythm patterns. And there's so much music, as in hip-hop, electronic music, dance music, where actually the rhythm and the sound is so much more important than maybe the melody or the songwriting. And you raised the point of substantiality, or what is it that makes a song so relevant. And I would say that in the case of Kraftwerk, I mean on Metall of Metall, but maybe the most famous Kraftwerk beat is Numbers, which was famously sampled by Afrika Bambaataa in Planet Rock. And I mean, this song, in that case, it's just a beat, but it's the beat that makes the song. And
it's the reason that they use it.
Yes.
That is precisely the reason.
These are just two observations I wanted to make. Yes, please, I would like to ask also the audience, if you do have any questions, let us know.
I just want to ask, another point of view is from the creator's view, that until 1970, most musicians played on instruments like a guitar or piano, and nowadays they are playing on a recording machine. So they are very often using this material as instrument, which is a bit strange, because if we would extend this view, we can say that a Bösendorfer, as a piano maker, could also claim money from the people who use their sound. Or Gibson, famous, or Stratocaster, you recognize the sound of this famous guitar, and they could say that Jimi Hendrix has to pay, because he uses this instrument and this special sound. This is when the law was created, this recording rights. there was no use of other recordings to make music. But now the whole creative model has changed, and the law doesn't reflect this at all, and also the discussion doesn't reflect this, in my opinion, because if we go to the way the music is produced nowadays, they use it as kind of instrument. So you can play a song on a flute or with an orchestra, you have a different sound. So this is well known in the classic, and and they also use the different kinds of sound for their own music, and it's not reflected at all in the law nowadays, in my opinion, or not even in the discussion.
Well, the German Constitutional Court made an attempt to get into this dimension, because they said, we have in German copyright this article on free use. So if you make use of a copyrighted work to produce something which is substantially different from the material that you have used, it does not matter that the material may have been copyrighted for the work it was in another context, but you're free to use it and make something substantially different with it. And this kind of free use is distinguished in many court decisions, minutely distinguished against the class of derivative works that also draw on previous works, but which are still recognizably related to the pre-existing work, so that they appear as a version of the pre-existing work. So an example would be the cover version. The cover version is also, to some degree, creative use of a previous work, but it's still perceived as a reinstantiation of a previously known work. Whereas sampling uses material from sound recordings to produce something that is completely different from the sound recordings that have been used for it. And the result is
can be completely different.
Independent work. Okay. It can, of course, be a mere copy of the pre-existing work, and I would claim in that case it's perfectly okay that the company who owns the distribution rights should also get a part of the remuneration.
Get paid.
Thank you. Maybe one more quick question.
I have a question for Professor Bentley. So this whole global mandatory fair use under the umbrella of quotation, how would you envisage that in the European system being implemented? Do you think this would happen through judicial activism by the European Court of Justice, and that we have this potential situation of a semi-open exception system like we have in Canada recently, or do you think, would this fit in an author's rights system?
Okay, that's a good question, the argument. For those people who aren't familiar, in the United States, for example, we have the fair use system, so a broad exception to copyright that's open-ended. In many of the European countries, the tradition has been to have a whole list of rather narrowly defined exceptions.
Lionel, get a little closer to the mic.
A whole list of rather narrowly defined exceptions. And one of these so-called narrowly defined exceptions is Article 5.3d in the Information Society Directive. And my argument is essentially that is a misinterpretation of that, to see that in the same way as some of the other exceptions, and to see it as just yet another of these narrowly specified exceptions is incorrect, and that when you read it in the light of the international norms and the proper meaning of those norms, that quotation exception itself should provide huge flexibility. Now, this depends, as you rightly point out, on the Court of Justice of the European Union buying into that interpretation. And it might be that they do it in this case. It is quite conceivable they don't even address quotation in this case, and they just decide it by reference to the part point. But another possibility is they'll reject my view. And then my view remains true as a matter of international law, but they've interpreted the EU quotation exception more narrowly. And then we have to find other ways in the back and forth between member states and the Court of Justice to make sure we're compliant with the international norm. So interpreting, for example, Article 5.3 little o, which is de minimis uses or analogous uses, those kind of provisions more broadly. But it's a great question. If the CJEU decides the Pelham and Hutter case, Hutter and Pelham case, in a particular way, the effect might be to put the EU in breach of international law.
Maybe I've got a last question for you, Tonya. And this is, could you maybe give a brief example, because you were ending your presentation with mentioning the possibilities that blockchain could have. So if we would use this technology, can you give an example of maybe how this court case that we spoke about could have been prevented?
Tie it all together. Uh-oh, I have to think on my feet. So if the main legal inquiry for the case is, I'm thinking about how to avoid this in its entirety, because and from the technology point of view, what the technology is good for is making information or data about transactions transparent. And through smart contracts, which is just little bits of code that say if then, if this happens, then that happens. If my artist sells 1,000 copies on iTunes, then this artist is paid instantly. So those are transactional and objective issues that I don't know that the technology at this point in time can solve for. I think it addresses other problems that can be quantified and reduced to some type of objective determination rather than something that's subjective.
If I understand correctly, the issue that Ralf Hütter had with this piece being sampled is an issue of control. He wants to have control over who uses his music and who doesn't. And there have been numerous cases where he has granted this right, but he wants to be asked. But
so from that perspective, absolutely. So from a smart contract, so one of the wonderful things that the smart contract technology does, above and beyond tracing and tracking, is also hard coding the if-then. If someone wants to use this track for more than 2 seconds, then they will have to do this. If they only use it for less than 2 seconds, then this. So in that way, you could use smart contract technology, and then there's no fighting afterwards because it will not happen. That license will not issue. There's no access to the recording unless and until.
And what you could also do in the smart contract, for example, is assign the drummer or performer of the track a certain percentage, which automatically, through each source of revenue, comes then to him.
Absolutely, and all of the artists and contributors, every contribution doesn't rise to the level of authorship, and that's a topic for another day. But at least you would know that there are everyone who participated or contributed, but in any stretch of the imagination, and what their percentage is. And you agree to that, and you code it up front, so that there's no fighting about it from an enforcement perspective down the line.
Thank you. Tonya, Lionel, Eberhard, thank you all for coming here today and presenting your very interesting and thoughtful ideas, and thank you for listening.
Thank you.
And please, if you're interested, bear with us, because in just 5 minutes we will have another talk here on music travels, copy cultures in the global mediascape, and I'm very much looking forward to this.